So we're going to talk about all of the changes to employment law in Ontario in the year 2022. And thank you for joining us this morning. And as Angelica said, if you do have any questions, feel free to put them in the Q&A section. The Q&A section is just an easier way to administer questions, and I'll be happy to answer your questions throughout the presentation, and at the end, I'll have saved time for questions. So what are we here to talk about? There's three areas that I want to talk about. There are two laws that were passed. The Working for Workers Act of 2021, which came into effect at the end of 2021, really had impacts throughout 2022. There was another law passed, which was called the Working for Workers Act 2022. So we'll talk about that. And then the newest case law, and really from most of it that I'm going to be speaking about today is from Ontario's highest court. And that is, the step below the Supreme Court of Canada. So when the Court of Appeal, that's Ontario's highest court, Court of Appeal for Ontario says something, lawyers take note and employers take note. And like I said, employment law has changed so much since COVID and the pandemic hit us. So before I get into those 3 points, I want to give a very, very brief update on COVID and how it's impacted employment law. So employers should know there's that very unique COVID-19 period, and it is ending on July 30th of this year. And that is where the Employment Standards Act permits an employer to place an employee on an unpaid, job-protected leave of absence. So if there are still any employees of an employer here that's listening today, and if those employees are still on leave because of COVID, not because of other reasons, but because of COVID, I would say speak with your HR department, speak with an employment lawyer, because the time is running out to deal with those employees. And it's important to have a strategy when you're bringing back the employees, or perhaps the business has changed and the employees can't come back. It's important to strategize that and deal with it now. So it's about 1 more month left. The vaccination policies, that has been a constant in the law for the past year, over the past year. They're right now not in force. And banks have been doing it, governments, now just recently airlines and airports are, for travel within Canada, you don't have to be vaccinated. So it is still a fluid situation, but could they come back? Yes, they could. They could, just as easily as they were implemented, and perhaps just as fast as they were implemented and taken away. And the last thing I'll mention, there have been 2 very recent labor arbitration cases where 2 labor arbitrators in Ontario have said there are some religious exemptions to a vaccination policy. Right now, it's just the first decision, the lower level decisions. They haven't been appealed. They haven't really been tested in court. So we are waiting for that. So that's just a brief update on COVID. Can't have an employment law seminar without talking about COVID. But we're here to talk about the employment law changes that affect us in 2022. So we're going to start with the Working for Workers Act. And like I said, it was passed into law at the end of 2021. And so the changes, for a lot of the changes that governments make in terms of employment law, they give time to implement them. So we're going to talk about that law and specifically what it entailed, because some of the changes came into effect just recently, in fact, a few weeks ago, at the beginning of this month. And like I mentioned at the top, it's the first of 2 bills that the government would propose to change, and not just the Employment Standards Act, but some other laws, including the Occupational Health and Safety Act. So, and some other acts after that, in fact. So those are where the areas that the law was changing. And like I said, the impacts are still being felt right now. So I've outlined these 5 most important areas that employers are dealing with right now as it relates to the changes from that first act. And I wanted to start off right from the very beginning to talk about the new policy called the Right to Disconnect policy. This is now in force. It is now the law in Ontario that employers who have at least 25 employees, they have to have a written policy on the right to disconnect. The law says an employer must have a policy. What does that policy have to include? Well, I'll tell you, and it's a short list. Number one, the policy has to be written. So you have to have a written policy that's entitled the Right to Disconnect policy. Number two, it has to apply to all of your employees, all of the employer's employees. Number three, it has to have a definition of the right to disconnect. And you can take that right from the law, from Bill 27, or really it's in the Employment Standards Act. You can find the definition for what does the right to disconnect mean. And a copy has to be given, a copy of the policy has to be given to every employee, or it has to be available for them to download somewhere where they can download and print it. That's it. That's what the law says in this Working for Workers Act of 2021. Those are the requirements for employers on the right to disconnect policy. There is nothing in the law that says what the policy has to contain, period. Now, I'll contrast that with employers who maybe they've been around the block a few times. They recall when the Occupational Health and Safety Act was amended with regards to workplace harassment and workplace violence. Those changes were a lot more specific. It was very specific what the policy had to contain, and not just a policy, but the employer was forced to have a program as well. As in, okay, well, you have this policy, but how are you going to administer the policy? So the Occupational Health and Safety Act says it has to be, with regards to workplace harassment and workplace violence, a robust policy, a robust program. It's written into the law. The same cannot be said about the right to disconnect policy. Like I said, it really has very few legal requirements for employers. The policy has to exist. It has to apply to all employees. The definition of right to disconnect has to be in there. That's the minimum. So some employers are using the opportunity to actually discuss, with their employees, what's the culture that we want? What do we want to cultivate in our operation? That's what some employers are doing, and that's, I think, very reasonable and a good thing to do. But there's nothing in the law that forces an employer to give that right to disconnect to employees. That's not what the law says. The law says the policy has to exist, and the title, the right to disconnect has to be defined. And make sure you give a copy to all employees. So, and this was effective June 1st. So there was a lot of talk a few weeks ago, 3 weeks ago, that employers were introducing those policies and how is it going to impact, especially post-COVID, and employees are working from home, possibly working more, working overtime. How does it affect breaks? How does it affect vacations? Those are all important things to discuss, but the law doesn't require the employer to have a policy on a right to disconnect, a specific, details on it. They just have to say, at a minimum, this is the right to disconnect. So I've been helping employers of all different sizes, small, medium, large, to come up with the proper right to disconnect policy. And it's important, if your business has at least 25 employees, you must have the policy. And anytime the policy is updated, you have to give a copy of that to all employees. And so you have to date it and update it. There was a question, does this apply to union employees? It applies to every employee in Ontario, period. So unionized or not, this is, if an employer has more than 25 employees, they should have a policy on a right to disconnect. It might be very short, it might be very long, but the policy does have to exist. So if there are any other questions about the right to disconnect, I'm happy to answer that. But I'll move on to the next point, which is non-compete agreements. Now this one is didn't come as a surprise to employers in Ontario, but the law now says any non-compete agreement that is entered into with an employee after October 27th, 2021, they are void, period. The law is very, very clear as it relates to most employees in Ontario. There's nothing, it doesn't say anything about it applying to independent contractors. It only applies to employees. And there are a couple exceptions to that. Number one, if the title of the employee starts with the word chief, as in chief executive officer, chief financial officer, chief information officer, if they are the most senior employees in an operation, the non-compete agreement can apply. Okay, that's one exception. And the other exception is where there is a sale of a business, and let's say the former owner sells the business and becomes an employee at the new business, which is purchased, there can be some non-compete agreements that apply there. So there are some exceptions, but generally this has reinforced what has been said in the law for years and years in Ontario, which is a non-compete agreement, to apply it to most employees is probably inappropriate, especially when a non-solicitation agreement could actually apply. And so courts are very happy to enforce non-solicitation agreements, not really non-compete agreements. And so for if you have any questions about how can we get a non-compete agreement applied, definitely speak to an employment lawyer. How can we get a non-solicit applied? Speak to an employment lawyer. But generally, non-compete, non-competition agreements are they have been very difficult to enforce in Ontario for many years. Now it's clear for almost every employee in Ontario, a non-compete agreement cannot apply. And actually, there was just a recent case that came out just last week or this week, in the middle of June 2022, and it again reinforced, let's say a non-compete agreement from before October 2021 that was signed by an employee. Any restrictive covenant like that, which is what we call non-compete, non-solicit, non-disparaging, they have to be reasonable. They must be reasonable. Even a non-solicit still has to be reasonable for it to be enforceable by an employer and by the court. So non-compete agreements, if you're thinking about doing one, speak to an employment lawyer and we'd be happy to help. There were some changes to, actually, we received a question about the right to disconnect. So I'm gonna go back to that. So someone asked, if we have production staff that physically cannot do their jobs the moment they leave the building, do they still need to receive the right to disconnect policy? Well, the answer to that is, number one, every employee has to receive a copy of the right to disconnect policy, okay? And the policy has to apply to all employees. But if it's, if an employee works in such a way that it's very easy for them to disconnect, such as, for this employee, that they're doing a physical job that can only be done from the office, it's very easy for them to disconnect from work. And so the policy would still apply, based on what that employer wants. And yes, they still need to receive a copy of the policy, and the policy generally has to, apply to, like I said, to all employees, including, those employees. Next, in the Working for Workers Act, there were changes to temporary help agencies. I won't get into all of the details about how it impacted temporary help agencies. But what I will say is, if you're an employer that uses temporary help agencies, there will come a time, it's not in force yet, but temporary help agencies are going to be licensed. And so it's important, if you use a temporary help agency or recruiter and things like that, that you ensure as an employer that the temporary help agency is licensed. And there are some obligations on employers to ensure that the temporary help agency is licensed. And so, it might just be in the standard welcome package from a temporary help agency. By the way, here's a copy of our license. It's important to obtain that. I mentioned at the beginning the end of the COVID-19 period. So back in October and December of 2021, the government signaled, hey, employers, if you have employees on a leave of absence related to COVID, the end of July is the last possible time that can be used. And this was pushed back. If employers have joined me for other webinars, we know it started in about May, and it went up May 2020, went to September 2020. Then it was pushed back to December. Then it was pushed back a few more months. Then it was pushed back more. And then the government said, okay, we're just going to push it from October. They announced it all the way to the end of July 2022. That's where we're at now. And I've heard nothing from my connections and from my networks or from the government. Haven't heard any indications that that's going to be extended. And I think just with where we are as a province in terms of, out of the stages, we're not out of the pandemic, but we are, working towards a recovery. I don't think the government is going to extend that. So again, as I said, if there are any employers here listening and they have their employees on a COVID leave of absence, it's time to think about how we're going to deal with those employees and bringing them back or dealing with them however the employer needs to deal with them. The last note from the Working for Workers Act 2021, and this might not apply to every employer, but it might not apply to every employer right away, but it has impacts for every employer. And generally, what the Occupational Health and Safety Act was amended to say, if there are people making deliveries to or from your workplace, you have to provide them access to a washroom. So people making deliveries, there are many different types of deliveries that are made to a variety of workplaces. And so this was, kind of the subtle nod to employers to say, we have to treat, these delivery drivers, some of them, they keep businesses running. Right? They make sure that, for logistics companies and things like that, they make sure that a lot of businesses are run properly and run smoothly. So ensure that there is a washroom there for them to use. And that's now written into the Occupational Health and Safety Act. There are some exemptions, which I won't get into, but generally, I think overall it's a good thing for employers. Now, there were some other changes in that in the Working for Workers Act that I didn't go over. But if you have other questions about any other changes to that, let me know. So that was the Working for Workers Act dated 2021, came into effect in December 2021. And like I said, that right to disconnect policy just came into effect in June 2022. So it's still, we're still feeling the effects now. But then earlier this year, quite quickly actually, the end of March and beginning of April of this year, the government, the provincial government passed the Working for Workers Act 2022. They use the same name, they just replaced the title, the year at the end and the title. So there's two Working for Workers Act. It was passed into law in April, which, as you recall, was right before the beginning of the provincial election campaign. I made a mention of minimum wage. There were no changes to minimum wage in the Working for Workers Act 2022. However, every political party in the election, just the major political parties, did all commit to increasing the minimum wage this fall. So we haven't seen those changes come into effect, including the government that was successful said they would also increase minimum wage this fall. So we're waiting for that. So we'll give our clients an update in terms of the changes there to minimum wage. But there were even more changes to employment law after December, when Working for Workers 2021 came into effect. 4 months later, a new law came into effect. So what did that new law have to say? Well, I split it up into two parts here. Some of it will apply to all employers. Some of it might not apply to all employers. Well, I really split it up between, the employment standards and, minimum standards in the province of Ontario, and then occupational health and safety, which, affects all employers in Ontario. So first of all, there's a new law that came into effect called the Digital Platform Workers' Rights Act of 2022. So what that did was it basically created a mini Employment Standards Act, but especially for digital platform workers. So, the digital platform workers, obviously, it's employees who are, they perform services for, digital platforms like Uber or Uber Eats, DoorDash, and other similar apps. Some of them, they're startups. That you could be a small digital platform, you could be a large digital platform, and that this law would apply to you. So basically what it's saying is it set some minimum standards for these digital platform workers, separate from the Employment Standards Act. But not every single protection under the Employment Standards Act applies to these digital platform workers. I won't go into the detail of them, but if there are employers here who they run a digital platform and they hire workers for the digital platform, it is imperative that they know about these new changes and the special minimum standards for those employees who perform digital platform work. The government defined it as the provision of or payment for payment, rideshare, delivery, courier services, or other work assignments through a digital platform. So it's important, like I said, any of those employers that they review that. Second, there were these changes to IT technology consultants. So first of all, currently in the Employment Standards Act, there are special exemptions for IT workers. And it is defined within the regulations of the Employment Standards Act, who is an IT worker. Because there might be workers who work for an IT company, but that doesn't necessarily mean they're an IT worker. And there might be employees who work for a non-IT related company, but they are in fact IT workers, okay, and IT employees. So it's important that for any business here who has IT workers, even if you don't run an IT business, but you have information technology workers, that you understand how the exemptions apply to those employees. So the law said here, it updated the law to permit, and I see I put IT technology consultant. I guess that's a duplication there. For IT consultants, there are now certain areas of the Employment Standards Act that doesn't apply to those IT workers, IT consultants. So they've expanded the exemptions for IT workers in Ontario. And this is important. Now, I also want to clarify, it doesn't apply to an IT worker who is an independent contractor. You may have a worker who works for you in IT, but they're an independent contractor. This wouldn't apply to them because technically, if they're an independent contractor, they're not an employee. Although there are some employers who get those confused sometimes, and I'm happy to clarify that for any employer who needs it. But there were additional exceptions for IT workers in the province of Ontario. I won't go into all of the details now, but it is important that employers and business owners understand what those are, because it may have impacts on their business, it may have impacts on how those employees actually work. The next one, and this one's important too. This one, it turned a lot of heads. Turned a lot of heads because it's not really something that I had heard stakeholders or employers ask for, or employees ask for, particularly. Very similar to the right to disconnect policy. That was something, the right to disconnect, we had heard about it in Europe, and there were some jurisdictions overseas that started to implement that. But it hadn't really been fully discussed in Ontario. Same thing with this electronic monitoring policy. There are other jurisdictions outside of Canada that have some forms of electronic monitoring, but not to the same extent that Ontario has. So this was a brand new policy. And what that policy is, in short, if you're an employer in Ontario and you have at least 25 employees, and the employer monitors their employees electronically, they have to have a written policy on it, and they have to disclose how the employees are monitored. Now, electronic monitoring, I've had lots of questions about, well, what does electronic monitoring mean? If we have a video camera, well, is that electronic monitoring? So it's important to, first of all, understand what the definition of electronic monitoring is. It's really, it doesn't, it might apply to, video surveillance and things like that, but really it's about, monitoring employees on their, work provided devices, work computers, work cell phones, and especially the devices. So there are some programs that employers use that they track when an employee is when the employees are using their computer, right? It might monitor how often they use a certain software. It might monitor even if they're using a work computer or work-based software. It might monitor every click and every button that the employee presses on the keyboard, keystroking software. That is the type of surveillance and monitoring that the employer has to disclose, not immediately. So later this year, the policy has to come into effect. Just like with the right to disconnect, it was introduced in December, really came into effect in June. There was some warning period, notice period for employers. The electronic monitoring policy has to come into effect, if the employer does it, in October of this year. So it's important that if there are any, if you're an employer and you do some electronic monitoring, it's important to, and if you haven't already disclosed it, it's important now, it is mandatory in Ontario to disclose that you monitor employees electronically. And it's not the same as the right to disconnect policy, which it didn't really explain what has to be included in the right to disconnect policy other than the definition. This makes it clear if an employer monitors their employees electronically, they have to disclose it. So I'm happy to answer more questions about that now or after the presentation, because it is new and employers still have some time to implement it. Now, there were some other changes to the Occupational Health and Safety Act, and these are significant. But employers may not feel the impact of these changes not immediately. They might feel them later. So there were three parts. First are the health and safety fines, the fines on corporations for breaches of the Occupational Health and Safety Act. So generally, the fines relate to employers not providing, all of the proper safety, protection to employees, and generally, a popular breach that prosecutors go for, generally is that the employer didn't take all reasonable precautions to protect workers in a workplace. That is the standard we're talking about. Okay, occupational health and safety. The law hasn't changed throughout COVID. It's been the same standard. Every employer in Ontario must take all reasonable precautions to protect workers, all workers in the workplace, wherever the workplace may be. So the fines for directors and officers was increased. So the fines for corporations, that had been a few years ago, that had been increased to the maximum fine of 1.5 million. That was increased a few years ago. But for directors and officers, previously, the maximum was $100,000 for fines. Okay, and that could mean there are some instances when some directors or officers of a corporation are fined in addition to the corporation. Right? So let's say for a breach of health and safety, especially a more significant breach like if there's a death at work. For officers and directors of a corporation, the fine went from 100,000, the maximum fine, to 1.5 million. That's the maximum fine that can be offered. So it matches the same amount as what corporations are liable for. Okay? That was a significant increase, right? An enormous increase. Okay? And when courts are setting fines, when they find a breach of the Occupational Health and Safety Act, they consider what the maximum is. They consider what other judges has said about similar breaches or the same breaches. They consider the other fines that have been given. But now, as of April 11th, when this law came into force, officers and directors now they face a maximum liability of $1.5 million. So it's significant. For any other individual, so not a corporation, not a director, not an officer, but let's say a supervisor in supervisors in Ontario, the maximum fine was increased to $500,000. Okay, and this is important for employers to know. Some of their employees, and not just a director or officer, a supervisor or a manager that they hire they do have liability and they have legal obligations under the Occupational Health and Safety Act. And if those legal obligations are not met, they personally can be faced with fines, a supervisor or a manager. Okay, now, this is an employee of a corporation, not the director, not an officer, and not the corporation itself, which is technically a legal person, the supervisor. The maximum fine for supervisors and other individuals, including employees as well, $500,000 is the maximum fine. So this is the government's way of saying, employers, you need to, make sure that they are doing everything in their power. Like I said, everything that is reasonable, to take all of those reasonable precautions. And it varies amongst different industries. There are, of course, very specific regulations in relation to construction and manufacturing and production and just the type of machinery that is used, working at heights. That of course came into law, I want to say around 2013. Mandatory training for anyone who works at heights, have to make sure that's completed. And I mentioned employees. There are some obligations on employees as well. Employees have an obligation to use equipment as directed and as trained by their employer. If an employer directs an employee to wear certain PPE and an employee doesn't, that employee could face liability. It would be rare, but they could face significant liability, like I said, up until $500,000. So it's and like I said, an employer may not know that they're facing that liability until a year or later after an investigation takes place. So, but it's still very important that a company does all of its due diligence, engages with its health and safety committee, make sure that the committee exists, make sure it's meeting regularly, and the company makes sure that the joint health and safety committee, or even just the health and safety rep, is informed of all of the health and safety issues that company faces. And I see there's some questions in the chat. So I'll come back to that. It deals with the electronic monitoring policy. And I'll come back to that. I want to address the Naloxone Kits. That's something else that was included in the changes to the Occupational Health and Safety Act. So if an employer in Ontario if they're aware, or they should have been aware, that there might be a risk of a worker having an opioid overdose where the worker performs work for the employer, the employer has to have a naloxone kit available for use by the employee. So again, it's only where the employer becomes aware, or they reasonably should have been aware, that the employee may need a naloxone kit, they must have one. So this might not impact every single employer in Ontario, but it really is a fact-based, an employee specific clause and situation. And again, it goes to generally the requirement for employers to take every reasonable precaution in the circumstances. So it's just really an extension of that. So if you're aware that as an employer or a manager or supervisor, aware that an employee might require a naloxone kit for an opioid overdose, you're required to have a naloxone kit. If you need help finding one of them, you can email my office. We'd be happy to help. And importantly, there was, the last change that I'll talk about in the Working for Workers Act is the extension for the Ministry of Labor to investigate infringements to the Occupational Health and Safety. Before April 11th, the Ministry of Labor had to bring forward the charge within 1 year, within 1 year of the incident. So, if the Ministry of Labor, sometimes you have to call the Ministry of Labor, sometimes you choose to call the Ministry of Labor after a certain incident. There are some mandatory calls you have to make. If there's a serious injury, you must call the Ministry of Labor. They would complete their investigation, and maybe 6 or 8 months later, then you get a note in the mail or an email saying, okay, there's a charge that's being brought against the company, possibly directors, possibly supervisor, possibly employees. They would have to do so in 1 year. 1 year from the it's 1 year from the last information they received about the infringement, about the situation. Previously, the law was 1 year from the date of the incident, but then it was pushed back to allow for the investigation to take place. But now it's 2 years. As of April 11th, the Ministry of Labor has 2 years to bring forward a charge and to complete an investigation. So that's in effect right now. So that means right now the Ministry of Labor can go back to an investigation maybe that was completed a year and a half ago from an incident that happened 3 or 4 months before that. They can, the time for the ministry to investigate and to bring forward charges has been extended. And like I said, that's in line with the increase in fines for directors and officers. It's significant. And employers should know, their obligations to keep records, their obligations for their, for training, their obligations to make sure their managers and supervisors are up to date, training for employees. Those records, they should be kept for, as long as possible, but especially now, if there's an incident for, 2 years at least, for that to be investigated by the Ministry of Labor. So those were some important changes. So for the prosecution to start, the Ministry of Labor has more time. So that's what I wanted to say about the Working for Workers Act. Now, I just want to go back to the questions that were asked. What needs to be in the electronic monitoring policy, and when is it effective? So the effective date for the electronic monitoring policy, I don't have that date in front of me. So Diane, if you send me an email, I can confirm the date for you. It's at some point in October of this year, but I can't recall the exact date. And what exactly needs to be in the electronic monitoring policy? So to speak in more general terms, so first of all, a disclosure that monitoring is done by the employer, how it's done, and for what purpose the monitoring is done. Okay, is it for surveillance? Is it for health and safety purposes? Is it for security purposes? Is it for privacy purposes? Is it to comply with contracts and obligations of the employer vis-a-vis third parties or clients or customers? The general reasons should be disclosed to employees. So we're just now starting to develop those policies for clients, and it's there's no one size fits all for monitoring because it can be different for every different employer. So it's something, and like I said, there's still some time for employers to discuss what is going to be in their electronic monitoring policy. So there's a question from Michelle. So she said they became aware that one employee might be using methadone for opioid dependency, and they don't know who is using that drug, but Michelle said, we assume that we now need to keep the Naloxone kits at our facilities. How soon do we need to have the kits in our facilities is the question. Question is immediately. or the answer is immediately. Okay, as soon as an employer is aware that they're reasonably aware or should have been aware that an employee might need it, they need to have it right away. And that law is in effect right now. So Michelle, if you wanted to reach out to me, I can connect you with people in your community or here in Mississauga and GTA and Peel region to help you with that, because if you have received that information from the benefits provider, not only is the naloxone, that special clause in the law now applied to you, but generally, like I said, you have to take all reasonable precautions to protect workers in the workplace. And as soon as you know about that, you have to act on it right away. So I would also say, you can engage with your health and safety committee. If you don't have a committee, the health and safety rep, to make them aware of that and to engage them in that. Possibly they can, arrange that for you on behalf of the company, the leader of the committee. And it's important that you show documentation and you record that as soon as the company found out about it, that you're taking steps. And perhaps, as a result of that, there might be additional training that you might give to managers, supervisors, and perhaps all employees. Not just one employee, not just one specific department. I would say make it general so that every manager, supervisor, or employee, whatever you feel is appropriate, is aware of that and is aware of how to use it. Okay. There's another question. Is it possible that some employers won't have virtual monitoring policy, or must they all have it? So the answer is no, not every employer has to have the electronic monitoring policy. First of all, it applies to employers that have at least 25 or more employees. So if you have less than 25 employees, you do not need to have the electronic monitoring policy, even if you monitor those employees electronically. But if you're a larger company and you don't monitor employees electronically, you do not have to have the policy. Okay. There's some other questions in the chat. There's a question here about someone's opening up a small business with 3 employees working. How do they get policies, details for their business? So that's something, we help at my firm. We help businesses all the time. Not just the right to disconnect policy, which is now mandatory. There are other mandatory policies that every employer in Ontario must have. That is, like I mentioned, workplace violence, workplace harassment policy. There should be a right to refuse unsafe work policy that every employer should have. That's something that's included in the Occupational Health and Safety Act. Generally, advise employers, it's not mandatory, but they should have policies regarding accommodation and discrimination in the workplace, just to set the appropriate tone and the appropriate culture in the office, in their workplace. So it's something we help with, and if any employer here needs assistance with those, we'd be happy to help. The last part, in the last time that we have in our presentation today, I want to talk about the case law. Okay, and by case law, I mean, lawyers will call it common law. It's also called judge-made law in Ontario. Now, these are changes to the law that they apply to employers as soon as the case comes out, but it's not really publicized, and it's not, you won't read about changes to the case law in the Employment Standards Act. So this is something, but those changes, a judge might change an unwritten rule of employment law, and it applies to every employer. So there are a few cases that have come out just recently that I wanted to highlight. So we're getting away from the minimum standards and more of the written or unwritten rules that govern employment relationships. So the first one, which I think is very important, I think every employer needs to know. There's these first 2 cases from Ontario's highest court, Court of Appeal. And in this first case, Render and ThyssenKrupp, the elevator company, the Ontario Court of Appeal stated that one single incident of misconduct could amount to just cause, just cause to terminate an employee. But in this case, it didn't constitute willful misconduct under the Employment Standards Act. And that's significant. In this case, to be brief, there was an employee and certain culture that the employer had, and one employee slapped the buttocks of another employee. It was kind of in a joking, camaraderie way, how it was explained. The employer didn't buy it. The employer applied, their policies about workplace harassment, workplace violence, and the employee was terminated for just cause because that was a single significant incident that they didn't tolerate. But the Court of Appeal said, okay, we agree that it's just cause. We agree that the employment relationship was terminated when the employee did that. But the court said, well, there was no proof that the employee willfully, did that misconduct. And again, it was an employee who slapped the buttocks of another employee. So because there was no proof that the employee willfully did it, as in, the employee was warned, if you even touch, let alone slap the buttocks of another employee, that it is, inappropriate. It was misconduct, but it wasn't willful misconduct. So that employee was entitled to the minimum amount of Employment Standards Act notice of termination. They weren't entitled to, months and months and months of termination pay, but they were entitled to the minimum amount. So this was a reminder to employers. They need to, make sure they investigate any misconduct carefully, and they, implement terminations carefully. There was another case that recently came out just last week. This was an interesting case, but basically the employer tried to argue, since the employee had legal advice when they were negotiating their contract, that the contract as it's written, it should apply. It doesn't matter if it's a good contract, not a good contract, in the opinion of a judge. The Court of Appeal said no. Even if an employee receives legal advice when they're negotiating a contract, if the contract should not be upheld, the court is not going to uphold that contract. And that was the Court of Appeal overturned the decision of the lower court. The Superior Court said, yes, I think it is fair if the employee negotiated with and had a lawyer, they should live with whatever's in that contract. But the Court of Appeal said no. The last two cases, which I'll touch upon just briefly, has to do with, okay, number one, this was earlier this year, but still very important. A 58-year-old employee who worked for 40 years, basically at one employer for their entire career, had limited education. She was entitled to 26 months of termination pay from the employer. And that exceeds the notional cap that the Ontario Court of Appeal had set. And what I mean by that is, when an employee is terminated, let's say they don't have a written employment contract, the maximum they could ever receive for notice of termination is 24 months, except for extenuating circumstances. And at the end of March, the Court of Appeal said this was an extenuating circumstance, someone who's, according to the court, a little older, a little more difficult for them to find a new job. They worked for basically one employer their entire career, and they had limited education. The court said, okay, we're going to exceed the cap on termination. And lastly, this was a brand new case that just came out very recently. An employer was forced to pay an employee, notice of termination, but they also terminated. The court also provided the employee with an additional $50,000 for untruthful, misleading, and unduly sensitive conduct. And that was, to make a long story short, the employer was selling the business, and the employee, it wasn't clear whether the employee was going to continue with the new business or not. And the employer made promises to the employee, yes, your employment is going to continue. Something changed before the sale happened, and the employer knew the employee's employment would not continue. But the employer didn't tell the employee that. But they still knew about it before the sale. And so a termination occurred afterwards, and those facts came out, and based on all of the employer's conduct, not just that, all of the employer's conduct, that employer had to pay the employee an additional $50,000 untaxed payment. So that's just a reminder for employers, the way that employees are treated at the time of termination, it is important, and it's something, it can't be treated lightly. Any employer has to treat their employees with, um, in good faith and fairly and truthfully and not misleading them. So those were the quick cases that I wanted to review. So we do have a few minutes, and I see a couple other questions. Yeah, I'll make sure in terms of my slides, I'll send a copy to Angelica, and then we can get a copy to anyone who wants them. Or alternatively, you can email me. Our website can be law.com. You can email me, and I'd be happy to send it for you. There was another question. They have a staffing agency. They have more than 25 employees, but the only ones we monitor are office staff. Would this policy include staff? The answer is yes, it does. If you have more than 25 employees in Ontario and you monitor employees electronically, you have to have the policy. So the person who wrote that question, if you wanted to reach out to me, I'd be happy to have a chat, just to go into a little more detail about that for you, and to make sure that the company is complying with the law, and make sure that it's a fair and reasonable policy for those employees. So if there are any other questions, now is a good time to ask. I'd be happy to address any other questions. I know we're just about under the time that we said we would go for. So, and if there are any other questions, I'm happy to, I can stay a little longer here. And you can also email me at jborelli@canbylaw.com, and I'd be happy to take more of your questions. Angelica, I think those are all of the questions that we have. And so I want to thank everyone for coming today and for your insightful questions. And for listening. And if you have any questions about the Employment Standards Act, Occupational Health and Safety Act, or any other changes for the law in 2022, we'd be happy to help.